we have the opportunity to make a habit of empathy.
Why might empathy matter? Why might it make a difference? Well, let's go back in history and take, for example, the history of the Colfax Massacre. Go back to Sunday, April 13th, 1873, when a gang of white men murdered more than 60 black freedmen in Colfax, Louisiana. Some were burned in a courthouse where they had taken refuge. Others were shot as they fled the burning courthouse. Others were taken prisoner and later that day executed. United States Attorney James Roswell Beckwith determined to prosecute white citizens involved in the Colfax Massacre. Not a popular call in those days. The case was tried before a United States District Judge, William B. Woods, who determined that rule of law should prevail in his district. Predictably, polite white society was outraged. And it took notable human empathy in that place and time to see the massacre of the black freedmen as a crime, and to contemplate trying white men for the murder of black men. The case was brought as one of the first applications of the Federal Enforcement Act implementing the Constitution's brand new 14th Amendment. So there was wide room for judicial discretion in that uncharted area of law. No balls and strikes, no phony umpires here. District Judge Woods assured a fair trial, but he was also prepared to honor Congress's desire that outrages upon the black community should be punished as crime. He had sufficient empathy with the widows and the children of the slain freedmen to take seriously their need for vindication. And he had sufficient courage to face the scorn and anger of the white community. Another judge was involved. United States Supreme Court Justice Joseph P. Bradley, who under the procedural rules of the time rode circuit for Louisiana and could sit in on trials. And sit in he did. He had no sympathy for the former slaves and little regard for Congress's intent to punish the abuse of freedmen. Disagreeing from the trial court bench with Judge Woods, Justice Bradley found repeated technical faults with the indictments, took a restricted view of the authorities of the 14th Amendment, dismissed the charges, and released the defendants to flee on low bail pending an appeal. The United States Supreme Court upheld its colleague Bradley's opinions, thereby gutting the 14th Amendment and the Enforcement Act for a generation. And thereupon, a wave of murder and violence by Klansmen and White League members, emboldened by de facto immunity from prosecution, swept the South. Reconstruction was vitiated in those weeks. Justice for the murder of a black man by a white departed the South for nearly a century. History and the law both ultimately proved District Court Judge Woods correct. But how much turned on the character of two judges? One who had the empathy to see black men as victims of crime and the courage to outrage white opinion by allowing the trial of white community leaders before a mixed jury, no less. The other, a judge who valued the status quo and recoiled from any shock to proper white opinion and authority, indeed who was the reflection of that proper opinion. That is what we mean by empathy. And while the divisions in our society are less today, there are still people who feel voiceless, whose voices a judge must be attuned to hear. There are still Americans who come to court bearing disadvantages that have nothing to do with the merits of their case. Empathy, to look through those disadvantages, to see the real merits of the case, even when it is unpopular or offends the power structure, is the hallmark of a great judge. The words of Hamilton, Holmes, Cardozo, and Stevens that I have quoted display that as history. The contrasting approaches of the two judges after the Colfax Massacre display it as justice. My Republican colleagues' misunderstanding of judicial history has led today to a missed opportunity for bipartisan support of a highly qualified and moderate judge who falls well within the mainstream of American legal thought. We could be celebrating the first Latina justice of the Supreme Court as a great and common bipartisan American achievement. Instead, here we are on the floor having to defend basic principles of American history from assault from the right. I hope that, as the future looks back on this day, it will be the historic nature of this nomination that will be remembered, not the strange and strained efforts to impose right-wing political orthodoxy on the courts that defend our constitutional rights.